Okay. 8 people in the waiting room. I'll admit all of them at once and we'll see who's here. Folks, please put your audio on mute until I call your case. Please put your audio on mute until I call your case. And I'll get started once everyone is connected. Looks like everyone is connected. Okay, I've got 3 cases set on the 10 o'clock docket. If you're here for Tropic Oil versus Old Florida Mining, please unmute. That's 19 CC 1581.
Steve Tonstel for the plaintiff.
Counsel, I'm sorry, what's your name again?
Stephen Tonstel.
Mr. Tonstel. Okay, good morning.
Good morning.
And you're here for Tropic Oil. Thank you. Good morning. Who's here for Old Florida Mining? I can't hear you.
Can you hear me now, Your Honor?
Yeah.
I can.
All right. Yeah, Tylen Ricketts for Old Florida Mining.
Did you say Ricketts?
Ricketts, R-I-C-K-E-T-T-S.
Okay, good morning, Mr. Ricketts. All right, this is Mr. Tonstel, your motion for summary judgment. You ready to proceed?
Yes, I am, Your Honor.
All right,
simple.
and all right, go ahead.
Yeah. Your Honor, it's a simple collection case. My client sold fuel to the defendant on credit, sent them bills, they didn't pay. Actually, it was February 3rd last year. We filed a motion for summary judgment with an attached affidavit by my client's credit manager and set forth those facts. Set the hearing for today, and here we are.
Okay, thank you, Mr. Tonstel. Mr. Ricketts, response, please.
Yeah, Your Honor, essentially the motion for summary judgment is just an insistence that they have proved their case without really any other justification. Our client has disputed the fact that the goods were delivered and that the account stated was accurate, and has filed a response and a competing affidavit to that effect. Additionally, those 2 causes of action, account stated and goods delivered, are mutually exclusive. So I don't know how a final summary judgment can be entered on both of those counts without it being a delineation. You'd have to delineate between the 2 causes of action. Otherwise, that order would be highly improper. And then finally, the underlying account was held actually by Mid-State and not by Tropic Oil. There was an assignment after the fact, after the goods were delivered. We don't want to be liable to the wrong party, Your Honor. So for those reasons, we believe that summary judgment's improper.
All right, thank you. Mr. Tonstel, anything further from you?
In reverse order. Number 1, yes, we have attached as an exhibit to the complaint the assignment where Mid-State Energy, who sold the goods to Mr. Ricketts' client, assigned all its right, title, and interest to this debt to Tropic Oil. We have alleged that, attached the assignment, etc. His second argument, I don't quite understand what he means that somehow accounts stated and goods delivered are somehow mutually exclusive. They're both legitimate causes of action dealing with one is I sold the goods I didn't pay for. And the other is we sent an account, we've done business with them. We sent account statements, they didn't object. How are they mutually exclusive? I don't quite understand that. And as far as the third argument, and the third thing,
Go ahead.
Anyway, they filed this affidavit a couple days ago. Let me see the date on this. 4th of February. Anyway, now I realize what he says. They disputed the accuracy. Account stated is inaccurate. Properly credit OFM for payments made, but there's no factual dispute. He doesn't say on this invoice, you charge us for 200 gallons and you only delivered 150. He just said, no, not true. there's no factual allegations here. He just says we disputed the account, the goods were non-conforming. In other words, they've denied our claim, but they haven't raised any facts to dispute our claim. And that's the argument.
Okay, thank you for your argument, and Mr. Ricketts, you as well. I have reviewed the court file, including the competing affidavits. Mr. Ricketts, you alluded to them. I know there's an affidavit in support of the motion for summary judgment, likewise an affidavit in opposition to it, along with, to my count, 13 affirmative defenses. And based on my review of the file, I certainly can't say there are no material issues of material fact. The motion for summary judgment is denied. Anything else from you two gentlemen today?
No, we'd be excused. Are you going to prepare an order, or what do you want to do?
I want you to send me a proposed order.
Okay.
And yes, you may be excused. You both can sign off. Thank you, gentlemen. Have a great day.
Thank you,
Judge.
All right. Next, we have, if you are here for Kidwell Group versus Citizens Property, please unmute. 20 SC 2212.
Good morning, Your Honor. Arnie Scardo here on behalf of Citizens.
Good morning, Your Honor. Leo Mannon on behalf of the Kidwell Group.
Okay, let me see, go in reverse order. Mr. Mannon, you're here for Kidwell, right?
Yes, sir.
And Mr. Izquierdo here for Citizens.
Correct, Your Honor.
All right, and we are here on Citizens. Mr. Izquierdo, your motion to dismiss and sanctions, right?
Yes, Your Honor.
And the basis for the motion is the validity of the assignment. Are you ready to proceed on your motions?
Yes, Your Honor. I would say that if I'd like to start with the motion to dismiss first, Your Honor.
Sure, go ahead.
Sure. So, Your Honor, so here we have just a brief background. This is a homeowner's insurance, first-party homeowner's insurance claim that was reported by the insured, Mr. Grossi, related to Hurricane Irma. The claim was ultimately denied. An assignment was executed in October of 2019 by Mr. Grossi in favor of Kidwell. And it's our position that this contract that was assigned, that was attached to the complaint here is invalid for it fails to comply with the new AOB statute 6277152. And the reason being, Your Honor, is that there's two ways, Paul, that coverage is triggered under this policy here. One way is direct physical loss, and the other way is any actions taken to remediate, protect, or mitigate damage here. Here, this contract, it's clearly not for direct physical loss, so it must be for the other prong here, as it's alleging compliance here. I mean, it's alleging coverage here with the policy. Because this contract fails to comply with 6277152 with respect to provisions such as the rescission language, the right to rescind 6277152, for example, 2A3, 2A6, and 2A5. Your Honor, we're moving here to dismiss on that ground.
Okay. And Mr. Mannon, of course, you'll have an opportunity to reply in just a minute, but Mr. Izquierdo, let me make sure I understand your motion, and because I read it, of course, and you refer to 627-7152 sub 2. And to me, this appears to be a fairly straightforward factual question, whether the language is in there or not. And you just specifically identified subparagraphs 3, 5, and 6. Are there any others in sub 2 that you believe are missing? Because then Mr. Mannon is going to zero in on those particular subparagraphs.
No, that was it, Your Honor. Those were the provisions that we're alleging we're not adhered to.
Well, I guess I don't know if this is maybe a rhetorical question. The exercise we're about to engage in together is we're going to go over the AOB and see if 3, 5, and 6 is in there. Isn't that something you two could have done yourselves? I mean, it's
Your
pretty
Honor,
clear it's either in there or not, right?
Correct, Your Honor, but I believe it's plaintiff's position that they weren't required to oblige with 6277152.
Okay, well, let's go to you then, Mr. Mannon. Your response.
Yes, Your Honor. So yes to what defense counsel just stated. It is our position that my client does not need to comply with 6277152 for the following reasons. First, 6277152 specifically states what type of assignment agreements it applies to. Specifically, it says that an assignment agreement must apply to services to protect, repair, restore, replace, or mitigate against further damages. My client performed a non-physical engineering inspection of the property in order to determine the cause and origin of the loss. As such, though an engineering report does not protect, repair, restore, replace, or mitigate against further damages. The statute is clear, and the statute needs to be read narrowly to what the legislatures were stating that this assignment law would apply to. The 6277152 does not define specifically which services are to protect, repair, restore, or replace, or to mitigate against further damages. So plaintiff's first argument is we're not required to, because engineering services are not to protect, repair, restore, replace, or mitigate against further damages. Plaintiff's second point of contention is that this new law, 6277152, cannot be applied to a loss that occurred in 2017. We rely on the case of Menendez. It's in my response, Your Honor. I'm not sure if you had a chance to review it, but the case is Menendez versus Progressive Express Insurance Company, Inc., 35 Southern 3rd 873 from the Florida Supreme Court in 2010. In Menendez, the Florida Supreme Court held that a new statute which requires new and substantive requirements in order to get into suit cannot be retroactively applied. What the Florida Supreme Court stated is that trial courts must look at the law in effect when the policy went into effect. For this particular claim, the policy went into effect on May 22nd, 2017. On May 22nd, 2017, there was no AOB law in Florida. None. There were no requirements for an AOB law. What had to be in an assignment of benefits, any conditions precedent that needed to be completed. In 2017, specifically in May 22nd, 2017, there was no law. So in accordance with the Florida Supreme Court's ruling, the court cannot retroactively apply 6277152 to a loss where the policy went into effect in 2017. Specifically, the Florida Supreme Court said the court needs to look at the law in effect in back when the policy went into effect, and cannot take into account when the lawsuit was filed, when the accident occurred, when anything else occurred. It is what the law was back when the policy went into effect. Third, Your Honor, it's plaintiff's position that arguing standing is improper in a motion to dismiss. Specifically, the first DCA in 2012 held that in Wells Fargo Bank of North America versus Reeves, 92 Southern 3rd 249, that challenging standing is an affirmative defense and not an issue of subject matter jurisdiction. Thus, standing can only be argued in a motion for summary judgment and not a motion to dismiss. Your Honor, those are the 3 points of contention in opposition to defendant's motion to dismiss. We would ask that Your Honor deny the motion to dismiss and ask them to file an answer within 10 days.
Mr. Izquierdo, your response.
Sure, Your Honor. So I'd like to reiterate what I had stated earlier, Your Honor. There's either two scenarios in which coverage is triggered here in this policy: direct physical loss, or for services to protect, mitigate further damage, et cetera. And that it's one of those two. Since it's not one, it must be the other. Simply to disguise yourself and say that it's not this, therefore, this doesn't apply. I mean, that it's clear on its face, Your Honor. And secondly, all the material cited and submitted by plaintiff here is not controlling. These are cases from across the state of Florida. Not one is cited even here within the second DCA with respect to considering standing issue on a motion to dismiss stage. Here, Your Honor, there is a case in the second DCA in which standing may be considered in the motion to dismiss stage, the National Collegiate Student Loan Trust versus Meyer. And this was a case from 2019 here, and essentially stating that, give me 1 second, Your Honor, just have a, pardon me. And which indicates that standing can be challenged in a motion to dismiss so long as in the face of the complaint there are allegations that demonstrate the existence of an affirmative defense here. And here, Your Honor, the lack of standing issue would be the affirmative defense issue that's referenced here. And here, one last thing. And that's it, Your Honor.
What do you say about counsel's reference to Menendez from the Florida Supreme Court and the retroactive application of 627-7152?
Your Honor, I believe the statute 627-7152 is very clear. It states that this applies to assignments signed on signed on or after July 1st, 2019. This was enacted in July. I'm sorry, scratch that. So that's our position, Your Honor. I believe that the statute straightforward and on its face indicates that this would apply to this kind of contract contemplated under the new statute.
I didn't quite follow your argument on the Menendez opinion. How do you distinguish that? Counsel, Mr. Manning is suggesting that Menendez, the Florida Supreme Court, indicates that 627-7152 cannot be applied retroactively. How did you just distinguish that, or did you? I didn't really follow your argument on Menendez.
Right, Your Honor. I would just say that the statute itself is straightforward and it applies to these kind of contracts.
Okay. Well, I agree. It's very clear if it applies, but I certainly can't issue a ruling contrary to the Florida Supreme Court based on my review of that opinion and Mr. Manning's argument. The motion to dismiss is denied.
Okay.
And Mr. Izquierdo, you also had a motion for sanctions, I think, which was based in part on the assumption that you would win that motion to dismiss, right?
Correct, Your Honor. So that would make that motion moot at this point.
All right. And so that 57-105 motion is likewise denied. And I'll ask Mr. Manning to send in a proposed order for each of those motions. Anything else for you gentlemen today?
That's it for me, Your Honor.
Hey, so I just want to confirm when I'm writing up the order, how many days are we giving defendant to file an answer?
Mr. Izquierdo, 20 days acceptable to you?
That's fine with me, Your Honor.
Okay, there you go. Thank you, gentlemen. Have a great day.
You as well. Thank you.
Thank you.
Thank you. Okay, next we have Plocharzik versus Messino.
Good morning. I'm sorry, go ahead, sir.
Mr. Plocharzik, I see you're here. Are you here representing yourself?
Yes, sir. Yes, Your Honor.
All right,
And-
and Mr. King?
I'm here on behalf of Ms. Messino. Good morning, Judge.
All right, good morning. Okay, Ms. Fraga, I see that you're here for a 10:30 motion. I'm going to send you back to the waiting room. I can't start your hearing until 10:30. Okay, so we've got Mr. King on behalf of Ms. Messino. It looks like she's present. I see her name. And Mr. Can you pronounce your name for me?
Plocharzik.
Plocharzik, okay. And this is, Mr. King, your motion to dismiss. You ready to proceed?
Yes, sir.
Okay, go ahead.
So, thank you, Judge. I think the court has probably already read my motion, and I think that was pretty straightforward. This is Mr. Plocharczyk's, his complaint is based on whether or not there was some sort of contract for Ms. Messino to pay for a breast augmentation surgery that she's had several years ago now, based on some sort of He says oral contract. First, let me say, Judge, that I understand Mr. Pisarcik's where he's coming from, his place of origin. He's coming from a place of hurt, and I understand. However, that being said, there's no express contract, there's no written contract. So this is an oral contract that was essentially within the four corners of his complaint was a gift. He was gifting this breast augmentation surgery to Miss Messino in exchange for her obligation only to remain in a relationship with him. Judge, what he's essentially doing is he has a bilateral contract, which means both in a contract and a bilateral contract, both parties should have obligations. Mr. Pisarcik has already purchased this gift and presented it. His assertion is that Miss Messino should be bound by the terms of their relationship to remain in a relationship despite what behavior, what conduct, anything that Mr. Pisarcik does, she cannot leave, or somehow it triggers her automatically owing this money. It is a contract not based on consideration, and it is not one of mutual obligation. In a bilateral contract, as Your Honor is aware, there must be mutual obligations. Mr. Pisarcik has no obligations in the contract because this is a past debt. This is consideration past, it's already done. And even by the terms of his own pleading, it was a gift if he decided to leave, which meant he had no obligation. If he decided to leave at any time he wanted to, he found a woman that he found more attractive than Miss Messino, he was able to break the contract without any type of repercussions. Moreover, Judge, when contracts, and Judge, I feel like I'm not like schooling you on contract law.
That's fine. That's all right. Go ahead.
This contract, when there's no consideration, Mr. Pisarcik's consideration becomes illusory at that point because he has no obligations under the contract. Not to mention, Judge, and I recognize it's a matter of affirmative defense, but it's a statute of frauds issue. There's an alleged oral contract for over $500, which violates the statute of frauds. And additionally, this is a contract really there's no time limit. 20 years later, Mr. Pisarcik come forward and say, hey, you know what? And Ms. Messino, after enduring 20 years of Mr. Pisarcik's torturous conduct, she said she wants to leave, and she can't. Otherwise, she has this $4,100 debt. He's coming from a place of hurt, and I understand, and the only place that he can attack her, Judge, is financially, and that's what he's trying to do.
All right. Thank you, Mr. King. Mr. Plocharczyk, your response to the motion, please.
Yes, Your Honor. Couple things here. I come before you because back in 2017, Ms. Messina had asked for breast augmentations a number of times. She was unable to afford it. As the attorney mentioned, I did in fact pay for it. The exhibits clearly show that. We had an agreement between us, and it was hence a deferred balloon payment. I did in fact pay for her augmentation. It was not a gift. Her words to me before $1 was ever spent or deposited for this as, how do we handle this? And I said, well, if we depart, this is a deferred loan. Okay, I'm not in the business to give away $4,100. She agreed to that. And then I have witnesses that can stand up. I have one with me right now that could confirm that agreement prior to any augmentation being going forward. She did in fact end it. I'm not coming from a place of hurt, emotionally. This was an agreement. It was a loan, a deferred loan. And that's what I'm trying to come up with. The oral agreement, an offer must be made by one person. She offered, I accepted. I did in fact pay for the 100%. I sent in the exhibits, my credit card, my, authorization to in fact do that. She parted ways. That was fine. And now I come before you. I tried to do this before, again, without the court. I've asked her numerous times to come forward, and if so, pay me $100 a month until you're done with no interest, not a problem. She left me no recourse but to come to small claims court. And again, I
Okay.
have witnesses that can attest to that.
Well, let me ask you a question. Well, first of all, a comment. I don't think Mr. King is disputing that you paid for it.
Right.
I didn't hear him say that. I didn't see that in the written motion. I don't think that's part of the argument today. I don't think that's disputed. But what do you have to say, Mr. Placharsik, about his statute of frauds argument, specifically that this is an oral contract? I think you've agreed to that, worth more than $500 with indefinite terms. In other words, it could certainly have lasted more than a year. And so one of the grounds for the instant motion is based on the statute of frauds. How do you respond specifically to that?
Well, Your Honor, I'm not, of course, not an attorney here, but this isn't a statute of fraud. I mean, this was an agreement that Ms. Messino and I came to agree upon. You know, she came to me with the offer, me being nice and so forth. I agreed, I accepted her agreement. And in doing so, if she could make comment to this, she would, you know, she agreed to, it was referred as a deferred balloon payment. I would pay for it to cover her expense. It was not a gift. If in fact we parted ways, she would owe me the money.
Okay. And you made the reference yourself that you're not a lawyer, and that's perfectly fine. You don't have to have a lawyer in small claims court. You've decided to come here on your own. But the fact of the matter is the laws still apply. And of course, I would assume that everyone who's here today would expect me to follow the law. And I agree with Mr. King. The statute of frauds is applicable based on the reasons that he indicated and I've repeated. I believe that this is not a valid enforceable contract. You said, Mr. Placharsik, you're not in the business of, but this wasn't a business decision. It was a personal decision. And so based on my finding, again, consistent with Mr. King's argument, this is not a valid enforceable contract. Mr. King, your motion to dismiss is granted, and I'll ask you to submit a proposed order consistent with that ruling.
Yes, Judge. Thank you.
Thank you, gentlemen. You're free to go. Have a good day.
Thank you.
What a
Okay, Madam Clerk, we've got our folks in the waiting room who are here for the 10:30. I'll admit them now.
Okay.
Okay, let's see. We've got Mr. Carney and Miss Fraga. If you can both, Miss Fraga, I'm not sure I'm pronouncing that right. Do you have video? Can you both unmute, please?
Morning,
Mr.
Judge.
Carney, good morning. Ms. Fraga, can you hear me?
Yes, sir. Good morning.
Good morning. Do you have video?
Yes, sir.
All right. Can you turn it on?
Can he see you? Yes. Can you see me, sir?
No, I cannot.
No?
All right. Well, that's all right. Let's see if we can proceed just based on the audio. Ms. Fraga, I've got a letter here that you wrote and sent to me on January the 11th, indicating that there was some technical difficulties. You asked me to please reconsider. And it says, I need my security deposit back. Will you please reconsider? And what you're asking me to reconsider, and I'm just recapping this for the record, is that we had a hearing previously on Mr. Carney's motion to dismiss, which I granted. And Ms. Fraga, you're asking me to reconsider that ruling, correct?
Yes, sir.
Okay.
Yes, sir.
And what's the legal basis for reconsidering that? I know that there were some technical difficulties, and I accept that. Okay, but you've got to present to me a legal basis to reconsider that ruling.
Sir, what I would like you to do is to please, when I rented this apartment from this person, it was Villas Isabel condominium where I went, and he showed me the apartment. I rented it for a year, and the apartment was not in a good condition, but I didn't know it until I started living there. And then I had issues with the water heater, the air condition, the electric, the stove had electrical issues. The refrigerator was full of bugs. And during all that time, I continuously paid him his rent faithfully on the 1st of every month. So
Okay,
I let him know.
Let me jump in here for a second, okay? Because I understand that everything you're telling me, and that's not really in dispute right now. Mr. Carney, when he argued his motion to dismiss, never really talked about any of those things. The basis for the motion to dismiss, Mr. Carney suggested to the court, basically, that you sued the wrong person. And so we're not really here to discuss the condition of the residence or your payment history, but whether you sued the right person. And I'm going to explain that to you briefly, and then I'm going to give you another chance to respond to this, okay? But I want you to listen carefully, because that's the issue, is whether you sued the right person. The issue is not the condition of the premises or your history of paying faithfully, I think is what you just said. And so what I want to do is I want to start by citing a case law. Well, first of all, I'm going to explain this as well. There are different levels of courts in the state of Florida, all the way up to the Florida Supreme Court. And when a court that is higher than county court issues a ruling, I'm bound to follow that ruling. Okay, and so we've got a 4th District Court of Appeal ruling, and the title of that case is Philip Schwartz Incorporated versus Gold Coast Graphics Incorporated, 623 Southern 2nd 819. This is from, the 4th District Court of Appeal. And what they say, Ms. Fraga, is, I'm just going to read the relevant portion. It says, an agent acting for a principal is not personally liable for the debts of the principal. Okay, so this is agent principal law. All right, an agent is not personally liable for the debts of the principal. So the question is, in your case, who's the agent, who's the principal? And in order to determine that, we just go to the lease agreement. And I'm sure you have a copy of the lease agreement, but I'm going to read some highlighted portions of the lease agreement starting on page 1. It says, lessee, that's you, Barbara Fraga, lessor, FL6 Incorporated, doing business as Villas Isabel Condos LLC. Further down on page 1, rent is payable to Villas Isabel Condos LLC. Further down on page 1, the lessee shall make a security deposit, which is the subject of this lawsuit, right? Your security deposit with the rental agent. So you are dealing with a principal, which is Florida 6 Inc. and doing business as Villas Isabel Condos, and an agent. On page 9 of your lease agreement, all payments should be made payable to Villas Isabel Condos LLC. Also on page 9, all rental payments can be made directly to Villas Isabel Condos LLC. On page 10, all rent checks shall be made payable to Villas Isabel Condos LLC. And then it repeats it, all checks to Villas Isabel Condos LLC, in all bold capital letters. And on the signature page, this is very important. On the signature page, it's got your signature, and it's got another signature from someone who is listed as the rental agent. And so the basis for Mr. Carney's motion to dismiss is not the condition of the premises. He didn't dispute that. He never really, not that he's agreeing with you, he didn't, but it's a non-issue. The basis for the motion to dismiss is that you sued the wrong person, because you sued Mr. Zorbalis individually, and he was the rental agent, not the principal. Based on the clear language in your lease agreement, the lessor is Florida 6 Inc. DBA Villas Isabel Condos. So I'm going to give you a chance to argue that point, but the basis for my ruling, Ms. Fraga, was that exactly that narrow issue, that you sued the wrong person. Do you have any response to that?
Yes, sir. I am not an attorney, as you can figure this out. And the reason that I sued, well, I just wrote, Mr. Sorvalos, was because he was the person always in his office. I made out the checks every month to Villas Isabel, like the contract stated. And he was the one that showed me the apartment. So everyone said that, he was the owners of those properties. And I thought, I'm not an attorney, again, as I repeat, and that's how I thought that I could, because I'm defending myself, that I should put the lawsuit. Okay, maybe I should have done it towards Villas Isabel, but I didn't know that. you know.
Okay, but maybe you should have done it, or you definitely should have done it. Now,
No, no.
what I just did, I just cited you a case from the 4th District Court of Appeal, which is binding on me. I have to follow that case.
Yes, sir.
And I cited all of the pertinent language in your lease agreement. And what you cited to me, Ms. Fraga, is you said, everyone said, you referred to anonymous people. Everyone said he's the owner. That's not sufficient. I understand you're not a lawyer, but obviously, I mean, if I were to set aside the dismissal and proceed, and then eventually, best case scenario for you is obviously you would like me to enter a judgment against the defendant for your security deposit, right? That's ultimately what you want.
That's all. That's all, sir, that I want.
Right, but I know, but think about that. I mean, you don't need to be a lawyer though to understand this. You can't actually be asking me to enter a judgment against the wrong person. I don't think you would expect me to do that. I can't do that. I'm not going to enter a judgment against the wrong person. And
Sir,
go ahead.
One question. I'm sorry to interrupt you.
Sure.
Even though that I made the checks payable every month to Villas Isabel, that doesn't count?
Well, maybe that's who you should sue.
That's what he's telling That's you. Yeah.
I mean, I'm not telling you that. What I'm telling you is who you should not sue is Zorbalos, because he's the agent. And the things that he did that you just explained to me, you said, well, he was always in his office. I gave the check to him. He showed me the property. That's exactly what an agent does. And so he is clearly the agent. And I say clearly, that's based on the clear language in the lease agreement that you signed. And so there can be no dispute about that. You are in a contract, not with Zorbalos, but you entered into a contract with FL6 Inc., DBA Villas.
Yes.
And so the basis for my ruling was just that very narrow issue that you sued the wrong person.
So can I start this process over again, sir? Because I really need my deposit back.
Well, I can't give you legal advice. Hold on. I know I'm not disputing that. I'm not debating with you that you need your security deposit back, but I can't give you legal advice. I can't act as a lawyer because I'm a judge. I have to be fair and impartial to both sides. So I can't give you legal advice on what you should do. All I can do is talk about the validity of what you've already done. And what you did was sue Zorbalos, and that's the wrong person. There's no question about that, given the facts of this case. And so I could have easily denied your motion, Ms. Fraga. You sent me that letter. Please, Judge, reconsider. And I set this hearing today to give you a chance to give me some legal reason and really to explain to you the basis for the dismissal. It's not about the condition of the residence or your payment history. It's because Mr. Carney raised an issue, correctly so, and he was exactly correct on the issue. You sued the wrong person. And so with all of that being said, your motion to reconsider is denied. My order dismissing the case stands. Mr. Carney, I do need an order consistent with that previous ruling. Can you send me an order dismissing the case based on that ground?
I will, Judge.
Okay, Mr. Carney, anything else from you?
No, sir.
Ms. Fraga, anything else from you?
No, sir. Thank you very much for explaining.
Okay, thank you both. Have a good day.
Thank you.
Take care.
All right, bye-bye. Okay, Madam Clerk, that is it until 11 o'clock.
Okay.
And we have 2 at 11 and 2 at 11:30. Well, so we will be in recess. I'll be back at 11 o'clock.
Okay, sounds good.
See you then. Amanda, you still with me?
I am, Judge.
Okay. 4 people in the waiting room. Folks, please make sure your audio is on mute until I call your name or your case. Please make sure your audio is on mute. All right, looks like everyone is in the meeting and connected. So this is a civil motion docket. I've got two motions at 11. The first one is Naples HMA versus Jose Tarubi-Artez, 20 SC 937. If you're here for that case, then please take your audio off mute.
Good morning, Your Honor. Sarah Jordan appearing for Naples HMA.
Good morning, Ms. Jordan. Is Jose Tarubi-Artez here or anyone for him? I've got someone listed as iPhone. I don't know who that is. So I'll call one more time. Is there anyone here for Jose Tarubi-Artez? No response. Ms. Jordan, I know that this is your motion for summary disposition, and notice of the today's hearing was mailed out on January the 12th.
Yes, Your Honor.
Give me just a second here to make sure that he was properly noticed. That notice does include the login credentials that you actually provided for him.
Hello?
So he was Hello?
Sorry, I was trying to make sure you can hear me now. I'm
What
Jose
is your name?
Tarubi-Artez.
Okay, do you have video?
Yeah, give me 1 second. I'm here at work.
Okay.
There we go.
Okay, I can see you. So you are Jose Tarubi-Artez. You're the one in the yellow shirt, right?
Yes, sir.
Okay, so Ms. Jordan is the attorney here representing Naples HMA, and we're here on her motion for summary disposition. In other words, she is here to ask me to enter a judgment against you because there are no disputed facts. Because the debt is owed and there's no reason to go to a trial. And specifically, Ms. Jordan, correct me if I'm wrong, based on your affidavits, you're seeking a judgment in the amount of $25,2346 for principal plus $380.85 for costs.
That's correct, Your Honor.
Mr. Tarubi-Artez, so my first question to you is, do you understand why we're here today?
Yes, I understand.
Okay, is there anything you want to say about that?
Give me 1 second. Sorry. I understand over here. It's because I went to the hospital one time, and it was for something about when my potassium was low, I believe.
Okay. And what she's saying now is that there's no dispute about the debt. The debt is owed, and there's no reason to have a trial on that because it's undisputed. So what do you have to say about that? This is your chance to address that before I rule on her motion.
The only thing I can say is that it's hard for me to try to pay everything, especially after my accident for a little bit there. And I'm still having a little trouble trying to catch up with everything because my accident was like 2-3 years ago, something like that. And I've been trying to, no matter what, catch up on everything. Even my house bills, I've been trying to catch up on those.
Okay. And that, Mr. Tarubi-Artez, that's perfectly understandable. And I don't doubt that. I'm sure Ms. Jordan understands what you're saying as well, and maybe they're willing to work out some sort of payment plan with you or work with you considering your financial situation. Ms. Jordan, would you be willing to do that, to talk with Mr. Tarubi-Artez about that?
Yes, of course, Your Honor. We're always happy to negotiate a settlement payment plan if that's what's required. I do believe a dispute arose at pretrial conference that caused this issue to get to this point.
Okay, so how are you?
If that's no longer an issue, then we're happy to negotiate.
All right, are you wanting to proceed on the instant motion or make that attempted negotiation first?
I mean, we're here, we can proceed on the motion if the court, if he's having trouble, if he doesn't want to set up a monthly payment plan, a consent judgment, or court's judgment can be entered and we can work out a payment plan after, if that would, that works for us.
Well, I think that would probably be best. Mr. Tarubiartes, so what we're discussing now is, remember, the reason we're here today is for me to determine whether I'm going to enter a judgment against you. All right, and that would be a court judgment entered against you. That's not a good thing. It would be an order ordering you to pay them a certain amount of money, and then you can still work out a payment plan with them after the fact. That's one option. I can enter that judgment today. Another option is if you're willing to make monthly payments, you and Ms. Jordan would have to talk about that on your own, not during the hearing today. If you're willing to enter into some sort of written agreement with her, then I think she would be willing to do that. And then the way the agreement normally works is this: you two, first of all, agree on the amount that's owed, and then you agree to a monthly payment. And then, Mr. Tarubiartes, if you successfully make every payment, then they would voluntarily drop the case. They would dismiss the case. So there would be no judgment entered against you. That would be ideal. But if you agree to make a payment and then you fail to make the payment, then they would be entitled to a default judgment. They would just send in an affidavit saying, Judge Crown, he failed to make this payment, and I would enter that judgment against you without coming back to a hearing. We don't have another hearing. And so that's how we typically resolve cases in small claims court. Again, the benefit to you is they would drop the case if you make all of the payments. And the benefit to them is they would get a default judgment without coming back for a hearing if you fail to make a payment. So, Mr. Tarubiartes, do you understand that process that I just explained?
Yes, sir, I do.
Are you interested in doing that and discussing that with Ms. Jordan?
Yes, I will.
And Ms. Jordan, are you agreeable to that procedure as well?
Yes, I'd be willing to do that. I just would like to, Your Honor, before I leave the hearing, I'd like to make sure I have correct contact information for Mr. Tarubiartes.
Absolutely. Do you prefer a phone number or email or both, or what would you like?
What's best for you, Mr. Tarubiartes? Is email easier or phone call better?
Probably email. If I can look at everything fully and understand it.
Okay, and what's an email address we can reach you at?
It's j2biartes87@yahoo.
87@yahoo.
Yes, ma'am.
And then last name as spelled.
That's my username for the email. Yes.
Okay. And if I may just quickly confirm, the phone number we have on file for you ends in 7836. Is that your
No,
correct
it's 239-888-7285.
285. I will update in our information. Okay, so we'll be in touch with you about setting up a call to discuss the terms of your agreement. Your Honor, should this negotiation between myself and the defendant not go well, what's the best practice to proceed?
Well, in that case, that's a good point. I was going to address that. Based on my review of the file and our conversation with my conversation with both of you today, I find that you are entitled to the summary disposition. I don't want to enter the judgment against Mr. Tarubiartes if I don't have to. So I'm hoping your negotiation is successful. If it's not successful, then I just need you to send in a proposed judgment based on the affidavits that are already in the file and an explanation to me that you made an attempt to resolve this and you were unsuccessful. And I would ask you to do that within the next 2 weeks.
Okay, yes, Your Honor.
Mr. Tarubiartes, do you understand everything we've discussed?
Yes, sir.
Do you have any questions for me?
No, sir.
All right, thank you. Ms. Jordan, how about you?
No, I believe that was the only matter today.
Okay, so what we'll do, Madam Clerk, is just note in the file that the hearing is canceled for today. Okay, thank you all. You're free to go.
Thank you, Your Honor.
All right,
Thank
have a good day.
Have a good day.
You too. Okay, next on the 11 o'clock docket, Velocity Investments versus Mendez, 19 CC 1461. Who do we have for that case?
Yes, good morning. This is attorney Jonathan Singer for the plaintiff.
Good morning, Mr. Singer. And Mr. Mendez, that's you,
Yes,
right?
Your Honor. Yep, that's me.
Okay, Mr. Mendez, I need you to raise your right hand to take an oath, please. Do you swear to tell the truth, whole truth, nothing but the truth?
I do.
Okay, and again, this is 19 CC 1461. Mr. Mendez, we're here because you filed a claim of exemption, and this is
Correct.
the hearing on the validity of that claim. Do you understand all that?
Sure. I do.
Okay, so I want you to start by telling me who lives in your household with you.
Right now it's me, my mother, and I have custody. One of my daughters. I have 3 daughters, but one of them.
Okay, and how old is the daughter who lives with you?
She's 10.
Okay, so it's just the 3 of you in the household?
Yes, correct.
Okay, and you said you have 2 other daughters, but they do not live with you.
Yeah, we're I'm separated currently, and I give her money, but I'm not on child support. I pay half her rent.
So it's not based on a court order, you're just doing that voluntarily?
Correct.
Okay, so where do you work, please?
I work at City of Marco.
All right. And are you paid hourly or salary?
Hourly.
What's your hourly rate?
It's $22.90.
$22.90?
Yeah, 22. Something like 22, some change, something like that.
All right, and how many hours a week do you work?
40.
Is that standard every week?
Yeah, 40. Yes.
Okay, are you paid weekly or bi-weekly or monthly?
Bi-weekly.
All right, what is your net pay, your take-home pay every paycheck? So that would be every 2 weeks.
After taxes?
Yes, sir.
$14.48.
$14.48 every 2 weeks.
Correct.
Okay, and you say you have 1 daughter in the home with you, and she's 10.
Yeah.
Do you receive any other assistance for her?
No, I don't.
Do you provide all of the support for your 10-year-old daughter?
Correct.
So her mother doesn't give you any money to help
No,
support her?
I actually pay her half her rent, and I also have to pay my rent, which is $1,800.
All right. Okay. Do you have any other source of income?
No.
Mr. Singer, do you have some questions for Mr. Mendez?
I don't, Your Honor. I won't spend the court's time on it. I don't have any other questions.
All right. Do you have any argument on the validity of his claim?
No, Your Honor. I can't really make a good faith argument to the court otherwise at this time.
All right. Well, I appreciate that. So, Mr. Mendez, based on your testimony, I find that your claim of exemption is valid, and I will sign an order to that effect, okay, to dissolve the garnishment.
Okay. Also, I have one question, Your Honor.
Sure.
Now, any funds that we're taking out that were garnished already, am I entitled to receive those back?
You will get those back, Mr. Singer. Do you agree?
Yes. I mean, as part of the standard order, sir, yes, you would get those monies back. If you're looking to try to resolve the judgment in general, we're happy to talk to you about it afterwards. But yes, the standard order would be that you'd get those funds back.
Okay, and do I have to do anything to contact you or anything like that, or does it just?
As far as the garnishment, no. Yeah, I mean, as far as settlement, yes, you're welcome to call us. As far as the garnishment, we'll take care of submitting the order. Once you get the order, if you want to get it to your employer, I mean, they'll get a copy from us as well. But if you want to provide them a copy, it may help speed up the process a little bit.
Okay, so as far as receiving the money back, I have to contact you guys?
That's your employer. We've not received any money yet from them. So how and the whens of they get you that money back, that I can't speak for. That's up to your employer. Actually, well, we do. It looks like we are holding some checks, so we will mail them back any checks that we're holding.
Okay. Oh yeah, I wasn't sure.
And Mr. Mendez, what I'm going to do as soon as we're done here today is go back to my office and sign an order. indicating that your claim of exemption is valid and all of the money that has been withheld needs to be returned and the garnishment is dissolved. So that'll be a court order that will go to your employer, so they should comply with my court order.
Okay, so will I receive an email from you? Or
You
is it
won't
just going
receive
to go
an email
straight to
from
them?
me.
Or it'll
It's going to
go
go straight to them. Madam Clerk, will Mr. Mendez get a copy of that? I assume he'll get a copy of my order as well.
Be emailed to him once it hits the docket, I think.
So I think you'll get a copy of it. It's not going to come from me though.
Okay, yeah, okay. And does it end up being within a couple days?
I'm going to go back and do it right now. I've got hearings at 11:30, but I've got 13 minutes to go back to my office and get this done.
Oh, I appreciate that.
Mr. Mendez, before we end though, something important that Mr. Singer just said is that you don't need to contact him regarding the garnishment, but if you want to contact him to discuss the balance of the judgment, then that might be in your best interest as well in order to avoid any future garnishments. Right? I mean, I'm going to enter an order dissolving this one, but Mr. Singer may want to try again on some other source of income or bank account to collect on that judgment. So it might be in your best interest to speak with Mr. Singer to see if you all can reach some sort of an agreement so you don't have to do that or go through this again.
Okay.
So let me ask you this. Do you have contact information for Mr. Singer, or would you like
Yeah,
that?
I saved all the paperwork that I received.
Okay. Mr. Singer, does he need any kind of account number, reference number when he contacts your office?
Nope. When he calls, we'll be able to locate him by name, and we have some other questions we usually ask for to make sure we're speaking to the right person. But no, he's just his name is fine to start with.
Okay. All right. Very good. All right. Thank you, gentlemen. That concludes our hearing this morning. So good luck to both of you, and you're free to log off.
Thank you very much.
Thank you. Thank you. Right. Bye.
Thank you. Bye-bye. Okay. Madam Clerk, I'll be back in 11 minutes.
Okay.
Amanda?
Judge.
Okay, so I am told that Ribocel versus State Farm canceled or settled.
Okay.
Let me let these folks, I've got 3 folks in. We'll see what they say. Folks, please make sure your audio is on mute before I call your case or until I call your case. All right, looks like everyone is connected. So I have 2 cases left here on my morning docket. The first one is Ribocel Chiropractic versus State Farm, 20 SC 1272. Is anyone here for that case? I didn't think so, Madam Court Reporter. Are you here for that case?
Yes, I am.
I was told on my way to court that they have settled. And so I think that's probably why neither of them are here, but it was so recent. I was literally told this less than 5 minutes ago that sometimes people still show up, which is why I called the case. I'm glad you did because you're here for that case. I'm sorry no one reached out to you to let you know that, but I believe again the parties have settled, which means the hearing today is canceled.
Okay, thank you. I appreciate it.
Okay, thank you. Have a good day. Okay, so Madam Clerk, that I don't see any kind of notice of settlement in the file, but the hearing for today's date is canceled based on that settlement. Okay, so that leaves us with 1 case left on our morning docket. That's Rostron versus Creekside Commerce Park, 20 SC 2991. I'm guessing both of you are here for that case. You can unmute, please.
Good morning, Your Honor. John Schmeeding, appearing as an officer of Creekside Commerce Park Property Owners Association, here with my colleague, Kristen Diaz-Garcia.
Okay, can you tell me your name again, please? I missed it.
John Schmieding, S-C-H-M-I-E-D-I-N-G.
Okay, Mr. Schmieding, and what's your role there at Creekside?
I'm an officer of that entity, Your Honor.
Okay, and ma'am, what is your name again, please?
Yes, Your Honor, it's Kristen Diaz-Garcia.
Okay, and how are you involved?
I'm an associate of John Schmied's.
Okay, so you're also here for Creekside. And then what is your name, please?
Francis Rostron.
Okay, you're Mr. Rostron.
Yes, sir.
All right, so Mr. Rostron, we're here because you sent me a letter about Creekside's failure, in your view, failure to comply with the terms of a settlement agreement, right?
Yes, sir.
Okay, are you ready to address that issue?
Yes, sir.
Okay, go ahead. First of all, what I would like you to do, Mr. Rostron, I'm sorry to interrupt you. I would like all three of you at the same time to raise your right hand to take an oath. Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, I do.
Yes.
Okay, thank you. You can put your hands down. Okay, Mr. Rostron, back to you, sir. Go ahead.
Yeah, on the 21st of December, when at the mediation, we settled on a figure with my costs, and the mediator clearly said that this must be paid by the 10th of January. And if it's not paid by the 10th of January, come and report it to the court. And if I've been paid, to bank the check, and when it's cleared, also report that to the court, which it says in the court filing here. On the morning of the 10th, on the 11th, which was a Monday, I'd not received it. So I came down to the court, went through the process of finding how to do it, and I had to write you a letter to say that I'd not received it. I did my letter, came back on the next day, the 12th, with the letter to you, saying that I'd not received it. That day, I got a phone call from someone at Arthex or Creekside, whoever it is, saying, oh, we've had a few problems in the office. We're doing your check today. Do you want to come and collect it? I said, no, you can post it. But I did tell them that I'd informed the court that I'd not heard from you, or I'd not received it by the 10th. So that was it. So I said, post it. And I got they sent it on the 12th, and then on the 26th of January, I had a phone call saying, we've got your second check here. Do you want to pick it up? And I said, you can post it, but I've also wrote to the court about this. And they said, I said, I've not even banked my first check yet, because I was advised to hold on to it with the post to say it wasn't sent since the 12th. They said, oh, well, if you bring the check in, we can give you one check for the full amount. I said, no, that's okay. Send me the second check. I'll bank them both together. And a week later, I got from them, I opened the mail and I got the letter that they sent you, fighting or whatever about the balance of my money. When they said to me to pick the check up, and it quite clearly says, should the defendant, and the mediator, the gentleman, also spoke to us both and said this, should the defendant fail to abide by the terms of the agreement, the plaintiff is entitled to a default judgment in the amount originally sued upon. In the event that full payment is made, the plaintiff must contact the small claims court, a voluntary dismissal, mediator, and this goes quite clearly. They have to pay by the 10th. They have 21 days to pay it. When the lawyer, the counselor, the lawyer asked me for my estimate for my repair receipts on the 21st of December, I sent them to him on the 22nd December and personally certified mail to him himself, to his name. and he received it on 11:26 a.m. the next day, the 23rd. They've had 3 weeks to pay this. So all the nonsense about it falls on a Sunday and somebody in the office, and with the resources of legal counsel, secretaries, it's just nonsense, I believe. You know, it quite clearly said I had to receive it by the 10th, not sent on the 12th to get on the 15th or whatever. You know, they had 21 days to pay it, and that's it, Your Honor.
So what is the current status of your payment?
They owe me a balance of $2,283 with not paying the first payment by the due date. The check for the first payment I have here, which is $2,633. And if it wasn't paid by the 10th, it was quite clearly that they have to pay the full amount by the mediator and the court's order. And then it's left you and me with all this nonsense and this hogwash about we've had problems in the office or whatever and this stuff. And they finally sent it on the 12th, which wasn't the 10th, you know.
So how much have you actually been paid?
$2,633.
Okay, and did you say that was the first check?
That was a half. That's what we settled on. But if they didn't pay, if they didn't receive that by the 10th, then they have to pay the full amount, which if they didn't get it, I didn't get it by the 10th.
You didn't get that first check by the 10th?
I didn't get this by the 10th. They sent it on the 12th, which is clearly in breach of the court order.
Did they send it on the 12th or did you receive it on the 12th?
No, they sent it on the 12th, and there is the stamp on the envelope. I received, I think, on the 16th, 4 or 5 days later.
Okay. All right. Anything else from you?
That's it, sir. But the court order quite clearly says I had to receive it by the 10th. They had 21 days, and it's irrelevant whether it fell on a Sunday. You pay your credit cards, you can't say, oh, well, I didn't have a check, or the date fell on a Sunday, or the post was slow. Otherwise, you get a late payment fee and an interest charge, you know. Quite simple.
Okay, thank you. Mr. Schmeeding, your
Yes,
response.
sir. Thank you, Your Honor. We processed this for payment with our management company the week prior to the 10th. As the 10th fell on a Monday, they wrote the check on the 11th, thereby calling Mr. Rostron on the 11th and asking him if he wanted to come pick up the check. And he informed Kelly Kennedy at Aaron Collier Companies to mail the check to him. I do understand he received it past that 10th date, but receiving the order with the date of payment being on a Sunday caused a little problems in getting that mailed to him by the 10th. So our position would be simply he informed them to mail the check to him and he received the payment, and that's the ultimate position.
So what is this about a second check? Has a second check been sent to him?
No, they asked to send
hold on, Mr. Ralston. I want to hear what their position is, okay?
No, sir. The record of agreement was to pay him the amount that he received, and his position is it was received late beyond the 10th, therefore we owe him another payment. But that was not the record of agreement.
It's not the record of, hold on a second. You say it's not the record of agreement? It looks to me like exactly the record of the agreement. Doesn't it say what he just said? Should the defendant fail to abide by the terms of this agreement, the plaintiff is entitled to a default judgment in the amount originally sued upon. And it says payment of $26.33 by January the 10th. I'm just curious, Mr. Schmeeding, how you can say that that's not the record of agreement. How is that not the record of agreement?
I meant that comment only as to the amount to be received by the 10th, was not the original agreement amount. The argument is that Sunday issue and his acceptance of it being mailed to him on the 11th was an acceptance of it arriving a little bit late.
Okay, so he didn't receive it on the 11th, right? He just told me it was postmarked on the 11th and he received it a few days after that. Do you agree to that, Mr. Schmeeding?
It was drafted on the 11th and postmarked the 12th. I believe he's correct when he says it, because it was put in the mail on the 11th and postmarked on the 12th.
So if you received it on the 13th or 14th, it's in fact 3 or 4 days late, right, past the deadline?
You are correct, Your Honor.
And so yes, go ahead.
Oh, I'm sorry, Your Honor. Just to clarify one point that I think is important is that Collier Commerce Park, our property management company, did reach out to Mr. Rostron on January 11th and said, I'm sorry, we have the payment ready for pickup today, which was January 11th. Kelly Kennedy spoke with Mr. Rostron and said, we have your check, it's right here available for you for pickup. And he said, no, I would prefer for it to be mailed. So Mr. Rostron knew that that was going to create additional delay, and if that was a problem in receiving it in those additional days, did ask Baron Collier to mail it. So he wasn't waiting for it that long. He could have gone to pick it up right that day, which would have been a 1-day delay to the payment. And Your Honor, we're asking that you respectfully review our motion, in which we laid out that we would like to rely on the small claims rule, that we would ask for the default judgment to be set aside based on the internal mistakes here of not being able to route the check in time for that January 10th deadline.
And what was the internal mistake that caused the delay?
Sure. So the receipt of damages provided by Mr. Rostron was sent to Mr. Schmeeding on December 23rd. There were some holidays in between that, and it did not get routed to the correct personnel to issue the check at the property management company. And so it caused this delay due to holidays and just getting it to the right person. And so we're asking for the court to view that as a mistake under this rule and set aside his motion for default judgment.
Okay, back to you, Mr. Rostron. Is there anything you want to say about that?
Yeah, they had 21 days to do this, and now they're saying it falls on a Sunday, which I think is irrelevant, and I should have had it by the Friday or the Saturday before it quite clearly says it had to be with me by the 10th, and it wasn't. And it's simple. It was a court order that they agreed on.
Okay, and so your hope here is that I actually order them to pay what, $4,500 instead of the $2,633?
Or the balance that they owe is $2,283. They offered to pay me one check for the full amount if I went down. I said, no, post me the second check. They said, we know we're in default and we want to pay you. They're not mentioning that. We're in default, we want to pay the balance. Can you come and collect it? I said, I've not banked the first check yet. Please send it to me. I'm a retired pensioner. I don't want to go out of the house and meet strangers as little as possible, you know.
Your Honor, if I may, could I respond to that?
Sure.
Mr. Rostron, we actually spoke. I was the person who spoke to you on the phone on the 26th. And after I reached out to you and asked you if you were interested in actually pursuing this default judgment motion for our 1-day delay in issuing the check to you. And I said, have you cashed that original check yet? To which you said no. I said, we still need to talk internally, but we may decide to issue a second one, but I haven't conferred internally yet. We will get back to you. And we concluded that phone call, and we went back to evaluate the facts and found out that Kelly Kennedy at Baron Collier had spoken to you on January 11th and had told you the check was ready. So after we had a chance to go back and evaluate the facts of what really happened, we didn't feel that it was amounted to the fact that we should accept default judgment in this case. So that's what prompted our response to the court on this. And I hope you can understand that a 1-day delay should not be grounds for, that would be our position, that wouldn't be due the entire balance.
Okay, Mr. Rostron, anything further from you?
No, that's not completely true, sir. It was a Tuesday they called me and said, we'll give you a check for the full amount. If you bring that other check back, we'll give you a check for the full amount. And I said, no, post the second check, please. I'll bank them both together.
Okay, well, let me comment. First of all, Mr. Rostron, you just mentioned earlier, I think a couple of arguments ago, that you're a pensioner and you want the full amount. But that was true at the time that you agreed to this lesser amount of $2,600, right? $2,633. You were a pensioner at that time as well.
Oh, yes, also, yes. I meant picking it up, going out as little as possible, you know.
Oh, yeah, in a way, and that wasn't your responsibility to go out and get that, right? It was their responsibility to get it to you. There's no question about that. And they did pay it. I understand you're also frustrated because they had since the 21st of December, and perhaps if they'd have started the process earlier, then there would be no delay and none of us would be here today. But the rule that Ms. Diaz-Garcia refers to is Rule 7.190, which is relief from judgment, order, or clerical mistakes. And they've represented to me that they had some routing issues, which caused this delay of a few days. And I have to be mindful of that. And the fact is that you've been paid the $26.33, which is exactly what you agreed upon. I think your words were hogwash and something else as a description of their explanation, and that might be true, but there's a rule of small claims court that indicates the court needs to consider that. And if they offer some sort of explanation that is reasonable, which would explain the clerical mistake, then I have to consider that. And so I know that you're here today hoping that I order them to pay the balance for a total of $4,566. That request is denied. You've been paid the $26.33. I agree with you that with the resources that I believe they have, they should have done better. And I hope that they do next time, because this is unacceptable. But for that rule, which provides for the possibility of mistakes. And they've represented to me that they did in fact make those mistakes. They encountered those mistakes in the payment of the money. And I accept that. I have no reason to doubt what Mr. Schmeeding, Ms. Diaz-Garcia have told me. And so the request for the balance is denied. You've been paid the $26.33. And that is the ruling of the court today. Mr. Schmeeding, you can present a proposed judgment, or not a judgment, but an order consistent with that if you would like to. Otherwise, as far as I'm concerned, you all agreed to the $26.33. It's been paid and the case is closed. Mr. Rostron, anything else from you?
I just understand when there's a court order saying they must pay by the 10th, and they didn't, and they say because it fell on a Sunday. I just think it's wrong.
I understand that, but you've got to read that in conjunction. You've got to read that in conjunction with the rules, which are promulgated by the Florida Supreme Court. I'm sure you understand I need to comply with rules promulgated by the Florida Supreme Court. All right, Ms. Diaz-Garcia, anything else from you?
No, thank you, Your Honor.
Okay, thank you all. Have a good day.